Good morning, everyone. My name is Dov Ohrenstein, for those of you who don't know me. Thank you very much for joining us. This webinar is about the new Practice Direction 57AC, which has just been introduced. It has effect from the 6th of April 2021. If you want to find the text of the Practice Direction, it's on the judiciary.uk website. It's not yet on the justice.gov.uk website. The new Practice Direction covers the whole of the business and property courts with only limited exceptions, and it makes substantial changes to the content of trial witness statements and how they should be prepared. I will talk about the relevant background to the introduction of the new Practice Direction and how the Practice Direction interacts with the established rules and the problems that the new Practice Direction is intended to address. Then, my colleague Laura Kreamer will address the detailed provisions of the new Practice Direction, and Shantanu Majumdar QC will discuss the tactical issues and the impact on how trials are conducted. If during the course of this webinar you have any questions or any thoughts that you want to share with us, please post them on the Zoom Q&A, and we will try to address some of them later. Firstly, dealing with the relevance of the old rules. Why are the old rules still relevant? Well, firstly, because the new Practice Direction is intended to complement, not replace, the existing procedures and rules. The intention is to ensure that the existing rules are applied with more vigor, at least for most cases in the business and property courts. Secondly, to understand what needs to be done following the introduction of the new Practice Direction, it's necessary to appreciate what judges thought was wrong about the old regime or about how the old regime was applied. So looking at the existing rules, we're all familiar with the overriding objective that requires cases to be dealt with justly and at proportionate cost. And we also know that the court has a duty to actively case manage cases so that they proceed quickly and efficiently. The specific provisions about evidence are in CPR 32, which states that the court has a general power to control the evidence by giving directions as to the issues on which it requires evidence and the nature of the evidence which it requires to decide the issues and the way in which the evidence is to be placed before the court. And that the general rule is that any fact which needs to be proved by the evidence of witnesses is to be proved at trial by their oral evidence given in public. CPR 32 also says that the court may give directions identifying or limiting the issues to which factual evidence may be directed, and identifying the witnesses who may be called or whose evidence may be read, or limiting the length or format of witness statements. Although this control can be exercised at any time, and the court can give directions about the length or form of a witness statement, the general reality, at least in my experience, is that save for some disputes about expert evidence or perhaps about Scott schedules, pre-trial directions about witness statements are usually totally non-specific. Directions usually say nothing more than the parties are to exchange witness statements of fact by such and such a date. There's been a historic emphasis by judges on party autonomy, despite the court's powers to control the nature of the evidence and the nature of the witness statement. Importantly, the rules say that the court will order a party to serve on the other parties any witness statement of the oral evidence which the party serving the statement intends to rely on in relation to any issues of fact to be decided at the trial. A witness statement is defined as a written statement signed by a person which contains the evidence which that person would be allowed to give orally. The idea is that a witness statement is to reflect what a person would actually be allowed to say if giving oral evidence, and that it is meant to be limited to issues of fact. And this is critical to understanding the purpose of the new Practice Direction and the way it is likely to be enforced. A witness statement must also comply with the requirements set out in Practice Direction 32, which says that if practicable, it must be in the intended witness's own words, and it must state the process by which it has been prepared, for example, face-to-face, over the telephone, or through an interpreter. For many witnesses, I doubt they use the words found in their statements, and save in cases where an interpreter has been involved, I have never seen a witness statement comply with the requirements of explaining that it has been prepared face-to-face or over the telephone or otherwise. The practice direction states that the court can refuse to allow non-compliant statements into evidence and may disallow the cost of their preparation. But to date, sanctions are rarely applied. Judges just usually ignore what they consider to be irrelevant passages from witness statements. The rules in the existing practice direction, part 32, are reflected in the specialist court guides. The Chancery Guide emphasizes that a witness statement must be confined to facts of which the witness can give evidence. And it is not, for example, the function of a witness statement to provide a commentary on the documents in the trial bundle, nor to set out quotations from such documents, nor to engage in matters of argument, expressions of opinion, or submissions about the issues, nor to make observations about the evidence of other witnesses. Similarly, in the Queen's Bench Guide, it says that statements should not include commentary on the trial bundle or other matters. The Commercial Guide echoes what is said in those other guides and adds that a witness statement should not contain lengthy quotations from documents. Accordingly, under the existing rules and specialist guides, witness statements' content should be limited to admissible factual evidence. But the reality is that there has been general non-compliance. This is because we practitioners have often taken the view that whether strictly within the rules or not, it assists our client's case if a statement sets out the full story, which often means having the witness go through the various documents and explain the arguments that will be relied on. This might sometimes be justified in appropriate cases, and the practice note in J.D. Wetherspoon plc and Harris in 2013 said that the rules as to witness statements that are set out in the Chancery Guide and elsewhere are not rigid statutes, and added that it is conceivable that in particular circumstances, those rules may be relaxed in order to achieve the overriding objective. A witness's account could sometimes include opinion evidence in order to provide a full and coherent explanation and account. But that's meant to be very much an exception. I confess that I have often advised witnesses to quote from documents in their statements, sometimes at significant length, because of concern that judges often only have time to pre-read the statements, but not the exhibits. Nevertheless, non-compliance with the rules on witness statements is thought to give rise to three particular problems. The first problem is unnecessary expense. This is not a new problem. It was identified by Lord Wolfe in his interim report in 1995, and then again in his final report in 1996, and in the Jackson report in 2009. Statements were said by Lord Wolfe to be an elaborate, costly branch of legal drafting. It's not just the cost of drafting the reports. The second problem is the wasting of court's time that flows from having irrelevant material in the statements. It was said in Cummings and Ministry of Justice in 2013 that court time is often wasted on submissions as to which parts of the witness statement are relevant and which are not, and on cross-examination on issues which, though referred to in the witness statement, are of little or no use to the court. And this is likely to be a situation that has been familiar to many practitioners. Whether the changes brought in by the new practice direction will actually reduce costs or save court time is something that we might want to debate. It may well be that those costs and the court time will be shifted simply from one part of the litigation process to another. The third concern is about the impact of the witness statement preparation process on the quality of the evidence itself. Perhaps in the light of the uncertainties about any cost savings, Sir Andrew Baker, the commercial court judge who has taken a lead role in the introduction of the new practice direction, recently suggested that his concern was more about the impact of witness statement preparation on witnesses' credibility rather than on reducing costs. How a statement is prepared can certainly impact on the weight that a court will place on it. For example, in the case of Assey against Dina Foods in 2005, His Honour Judge Coulson, QC, commented that while it's sometimes the case that witness statements are drafted by solicitors, the solicitors will always endeavour to speak to the witnesses first and put down their evidence in their own words. In that case, that's not what had happened. the claimant himself had arranged for the witness statements to be prepared. And those witness statements included the wholesale repetition of phrases, sentences, and even entire paragraphs in statement after statement. His Honour Judge Coulson said that this reduced and possibly even extinguished altogether the reliability of the evidence prepared in that way. The written statements provided on behalf of the claimant in that case were inherently unreliable because they were drafted by the claimant himself with scant regard for the evidence that the relevant witnesses might themselves have given if their evidence had been prepared in the conventional way. Now, I'm sure that the concern about the accuracy of the statements obtained by lay clients was well-founded, but I suggest that the client's statement that solicitors will always endeavour to speak to the witnesses first and put down their evidence in their own words is not accurate. I've certainly seen solicitors' statements prepared by solicitors, which have cut and pasted text from one statement to another for multiple witnesses. In any event, solicitors are under a duty to ensure that statements are taken by persons who can be relied upon to exercise the same standards as should apply if statements were taken by the solicitors themselves. But, as was said by Mr. Justice Toulson in the Delphine in 2001, if bad practices in the taking of witness statements come to be seen as normal, so that witness statements become lawyers' artifacts rather than the witnesses' words, their use will have to be reconsidered. Central to the problem is the ignorance of the court and of the other party about how any witness statement has in fact been taken. It might therefore be thought salutary that where a witness statement is prepared by somebody other than the witness, there should be a written declaration by the person who prepared the statement giving information about how, when, and where it was prepared, and certifying compliance with any appropriate code of practice. That was back in 2001. But you'll see now that 20 years later, this is something which finds echoes in the new practice direction. The problem is not primarily one of dishonest or over-enthusiastic parties putting words in the mouths of witnesses. It's a problem with the professionals, solicitors and barristers involved in the process of taking a statement, and, importantly, with the litigation process itself. As was said in Earls against Barclays Bank in 2009, where it is apparent that the statement of a witness has been drafted with considerable assistance from solicitors, the judge's task of evaluating the witness's credibility is made more difficult. The process of taking statements, even when carried out by professionals, is perceived as impacting not only on the statements themselves, but on the witness's ability to recall events accurately. Mr. Justice Fancourt, another judge who's been instrumental in the drafting of the new practice direction, made similar comments in the Edwardian Group case, where he said that the witness statements, which were products of careful reconstruction of events and states of mind, by meticulous examination of all the documents in the case by large teams of lawyers, lacked the true voices of the witnesses. This is not to be taken as suggesting that the witnesses are being deliberately dishonest about parts of their evidence. Rather, he said that the process of creating the written statements had infected or distorted the true evidence that the witness was capable of giving. So, while conscious impropriety is not thought to be prevalent, the idea that memories are often corrupted by the trial process has become a regular part of party submissions and court findings. This is often by reference to the well-known 2013 decision of Mr. Justice Leggett in Gessman against Credit Suisse, where he emphasized that memories are malleable and that considerable interference with memory is introduced in civil litigation by the procedure of preparing for trial. This is partly because the statement is usually drafted for the witness by a lawyer who is inevitably conscious of the significance of the issues in the case. The witness's memory has been refreshed by reading documents, including statements of case and other argumentative material, as well as other documents which the witness did not see at the relevant time, and that the statement can go through several iterations before it's finalized. Until months later, the witness will be asked to reread his statement and review documents before giving the evidence in court. Mr. Justice Leggett said that the effect of this process is to establish in the mind of the witness the matters recorded in his or her statement and other written material, whether they are true or false, and to cause the witness's memory of events to be based increasingly on this material and later interpretations of it, rather than on the original experience of the events. So that is really the primary concern, at least of many of the judges who have been driving the new practice direction. So, having identified the problems that the new practice direction is trying to remedy, I'll now hand over to Lauren to explain the detail of the new practice direction.
So over the next 15 minutes or so, I'm going to go through who the rules apply to, the content of witness statements, the fabled statement of best practice, and then a couple of procedural matters, and then finally and merrily sanctions. And then after I've kind of done a whistle-stop tour through it, Shantanu will talk about the likely effects of those provisions, the impact on trials and on proceedings. So firstly, when does it apply and when doesn't it apply? Para 1.1 of the practice direction provides that it's witness statements for use at trials in the business and property courts in new and existing proceedings, but only to witness statements made after the date that the practice direction comes into force. So you don't have to go back and retrospectively make your witness statements compliant if they've already been made in existing proceedings. But the fact that the proceedings commenced before the April date is no reason not to make your witness statements compliant. For use in trials, I'll come back to trial witness statements in a bit more detail, but it means a final trial hearing, whether that's of all of the issues or one or some particular issues. And it's Part 7 and Part 8 claims. It includes unfair prejudice petitions under Section 994 of the Companies Act and contributories just and equitable winding up petitions under Section 1121G of the Insolvency Act. Now, that all sounds quite broadly defined, but there are a very significant number of exemptions, some of which are very narrow and some of which are extremely broad. There are 9. Some of them are relatively niche, certainly for my practice and many of yours, I suspect. Certain applications and proceedings under FUSMA, and specific applications. But then in amongst those, you have the very broad category, an application for an order under the Insolvency Act or the insolvency rules. So other than contributories just and equitable winding up petitions, which are expressly carved out, you don't have to worry about this if you're dealing with insolvency proceedings. So we had a couple of questions with regard to this sent in advance about insolvency and the impact of this on that sphere. At the moment, very little, because it doesn't apply to those proceedings. You've also got some more very general categories, which are Part 57 and Part 64. So you've got probate claims, you've got rectification, substitution, removal of PRs, and 75 Act claims, all exempted, as well as Part 64 proceedings, so administration of estates and trusts and charity proceedings. And then there are some more kind of general or wide-reaching exemptions. So it doesn't affect affidavit evidence, doesn't affect evidence in a witness statement other than a trial witness statement, and I'll, as I've promised, come back to that momentarily. And it doesn't affect the application of any other rules. So if there are any other rules or practice directions which say you have to include certain things in a witness statement, those still apply. They're not overridden by this. And that's contained there in the practice direction. So as promised, a trial witness statement. So it puts it in the reverse. It says the practice direction does not apply to witness statements other than a trial witness statement, and so only applies therefore to trial witness statements. I've put the text up here, but as usual, unhelpfully, the definition includes a lot of annoying cross-referencing back to other parts of the CPR rather than just saying what it means. And so when you replace those cross-references to other rules and other parts, what you get is a definition of a trial witness statement, which is as follows. A statement of the oral evidence which the party serving the statement intends to rely on in relation to any issues of fact to be decided at the trial. A statement filed with a Part 8 claim form or in response to a Part 8 claim. Any other evidence filed in a Part 8 claim with the permission of the court. And then expressly, once again, you've got your just and equitable winding up petition and your unfair prejudice petition set out there. So those are the statements which to which this practice direction applies. So what do they have to have in them now? Well, the practice direction at para 2.1 provides that the purpose is to set out in writing the evidence in chief that would be given if the witness were to be giving their evidence orally. And as Dov mentioned, it states that the practice direction now states that the use of witness statements must promote the overriding objective. So it's explicit about litigation being conducted justly and at proportionate cost. Now, this brings us to what all of this really means for witness statements. What should be in a witness statement served in accordance with the new regime? Para 3 of the practice direction provides that it must contain only evidence as to matters of fact that need to be proved at trial by the evidence of a witness. And once again, it repeats, and it's pretty emphatic about this, the evidence as to such matters that the witness would give if called to give evidence in chief. More specifically, it provides that the witness statement must state only that which the witness claims personally to recollect about matters addressed in the statement. So presumably, the idea is to do away with the "I have been told and believe" kinds of statements. This is matters which only which the witness recollects themselves. And there's a bit more detail about that in the statement of best practice, which I'll come on to. It must also identify the documents that have been referred to, but only those which are strictly necessary to deal with the matters being explained. And I'll come back to that in relation to the statement of best practice. And then once again, the practice direction restates what Dov mentioned earlier, which is compliance with practice direction 32 para 18.1 and 2. So this thing that we should include but never do about how it's been prepared and being in the witness's own words, and as I say, it being explicit about the process by which it's being prepared. So we come on to the statement of best practice, which is a wishy-washy sounding document. It's at once sort of meaty and a little bit wishy-washy because it's a statement of best practice and not rules. It's worth having a read in full, but I'll try to summarize briefly the content of it. It sets out some background saying essentially that the business and property courts often have trials where matters of fact don't need witness evidence because they're common ground or it's documentary and the effect and meaning of the documents isn't disputed. But it comes back to this point about factual witnesses needing to give evidence as to matters they witness personally. And then we get quite specific about what that means. A matter would have been witnessed personally if it was experienced by one of their primary senses, and helpfully sets out for us what the primary senses are, or if it was a matter internal to their mind. And so it's quite clear, again, that the focus comes back not to commentary on documents, not even to documents, but to matters which a witness witnessed personally, and not really anything else. And then there's a bit more clarification about that, and it explains that it may be necessary if there's some dispute about what exactly they thought at the time, then it's permissible for them to set out their thoughts, even though that's not necessarily something that falls within the primary senses category. Then we come on to documents. Now, before I go through all of the documents, there are some other general elements which are contained in the practice direction or in the statement of best practice. Things like no pressure should be put on a witness to give anything other than their own account. I suspect that's not particularly new or surprising. There's also emphasis on witness statements being as concise as possible. And then we come to documents, and essentially what it says is that documents should only be referred to, if at all, where necessary. So clearly what's envisaged is that there may be witness statements, and there often should be witness statements, which don't refer to any documents at all because they're describing factual events. And of course, that's a considerable move away from the current process of providing lengthy and producing lengthy exhibits. So no doubt music to the ears of trainees throughout the land who have gone through the pain and suffering of compiling those exhibits on a number of occasions. Documents will only be required where essentially what you're saying is this is the document that I saw and not another version or something similar to that. And there's an explanation in para 3.4 there of how that works. And then you also have at the bottom the sort of repetition, the emphasis, don't exhibit a document unless it hasn't already been disclosed. Of course, it should have been disclosed if it's relevant. And if it has been disclosed, then you can come back and look at and refer to it by referring back to the disclosure. And again, and Shantanu will touch on this, but it puts more emphasis or shifts the focus onto disclosure and that having been done well, and therefore being able to identify documents from disclosure. It also says no lengthy quotes from the documents, no arguing the case, no commentary, whether on your own case or on the other evidence in the case, whether put forward by the other side or somebody else. And the practice direction also wants fewer drafts, and it says that any process of repeatedly revisiting a draft statement is likely to corrupt rather than improve recollection, which is probably true, but it's clearly a point directed at legal representatives that working on having draft 53 is unlikely to contain a genuine recollection from the witness of what happened. And I think that's essentially what I've just set out. And so we come to preparation. Now, this again is another part which is slightly new. It's explicit that witness statements should be based on records or notes made by legal representatives from interviews. It says that other methods are permissible, but really interviews are what's ideal. And in recognition, no doubt, of current remote practice, recognises that those can take place remotely, but nevertheless says that there ought to be a record or note of those interviews. And it also requires that the interview shouldn't use leading questions, should use open questions, should be recorded fully, and the recording retained. So quite important things here for lawyers to note, quite a change from some of the typical practices of sort of emails back and forth in order to prepare, or exchanging drafts back and forth in order to prepare witness statements. Now we have something a bit more akin to the US system of depositions, maybe, where you're taking down, you're asking questions, you're taking down the answers, and that then comes into a witness statement form. It does recognise that lawyers can structure the statements, and the quote is take primary responsibility for drafting the statement, but nevertheless the content must come from the witness and must be taken from the record of their interview. There are also some specific provisions in there which it's worth having a glance over for litigants in person, very similar themes, but in, as you would expect, more straightforward language. But it does make clear, importantly, that these provisions do also apply to litigants in person. So it's no excuse or defence, as you would expect, as per usual, for a litigant to say, well, I'm a litigant in person, I didn't understand or didn't know that what a witness statement had to look like. And it's explicit in that section, finally, it says witness statements must not be used to argue the litigant's case. So useful reminder for litigants in person there. A couple of procedural points. These slides will be circulated, so you'll have these, and the text is in the practice direction anyway. This is the new statement of truth. The first part is the old bit, or not that old, it's still relatively new, but the current version. The bit underneath is the new bit, and it's for the client, it's for the witness rather, and says that their lawyers have explained the practice direction to them, or someone has explained the practice direction to them. It's worth noting that this appears to remove the option for lawyers to sign the statement on their client's behalf, particularly given the certificate of compliance which follows, which I'll come on to now. So witnesses, it seems, are intended or should be signing their own statements, and that's of course in accordance with the general principles underlying this practice direction, that it's the witness's statement in their own words produced by them. Certificates of compliance are new. It says that alongside the statement of truth, you need to endorse the witness statement with a certificate of compliance. And this does have to be signed by the legal representative, unless, of course, you're a litigant in person, in which case you don't have to have your legal representative sign it. The practice direction, the text is there. The practice direction doesn't specify whether this needs to be on the witness statement or on a separate document attached to it. I think given its length and given that it sort of has the character of a statement of truth, I would be inclined to insert it below the statement of truth as part of the same document. But you will see that this introduces an obligation for the lawyers to sign this, to state that they have acted in accordance or drafted in accordance with the practice direction. And then finally, maybe the bit we actually care the most about, what happens if you don't comply with the above. I suppose in a sense, who knows, because it's hard to know how much these will be enforced. And I think Shantanu will come on to discuss that a bit. But they're pretty onerous. There's a very general section or paragraph which provides that the court retains its full powers of case management, so essentially it can do anything. But there are some specific sanctions envisaged: striking the statement out, refusing to give permission for the party to rely on all or part of it, ordering that it be redrafted, which would be a pretty staggering sanction on the morning of the trial for a judge to impose, you can imagine. Adverse cost orders, and again, something which sort of certainly struck fear into my heart, making the witness give some or all of their evidence orally in chief. So again, potentially coming as a bit of a surprise to the advocates if that's ordered straight away. There's also finally a slightly odd sanction which relates to striking out a statement which has a certificate of compliance where there is reason to think that the party only acted in person at the time to avoid the obligation to include a certificate of compliance from applying. Very hard to see where that will ever happen, but anyway, that's been included by some very suspicious draftsperson. So some potentially quite severe sanctions, some very costly ones indeed, and I think that probably brings us on nicely to Shantanu's views on what effect this is likely to have.
Well, I'm very grateful to Dov and to Lauren for providing the meat of this webinar. And it's now been left to me to provide what I think inevitably at this stage are some fairly speculative musings about what are some of the implications of this new practice direction might be in practice. But I begin perhaps slightly some futility perhaps by saying that you could be forgiven for wondering whether this latest procedural reform is yet another attempt to bend a process designed for the 19th century to the shape needed by the 21st. Now, we're told that nothing was off the table when the witness statement working group considered what to do about witness statements, but also that they had little appetite for radical reform, which means I think we're going to have to wait for that to come. What they have done, and which Lauren has just taken us through, has an impeccable logic to it. If you accept the premise that a witness statement should contain only the evidence which that witness could give in examination in chief. Now that, of course, is what the relevant provisions of Part 32 have always said. And from that perspective, Practice Direction 57AC ought to achieve its purpose. However, as the working group behind the practice direction itself recognized, witness statements which currently routinely contain a detailed factual narrative derived largely from the documents serve a legitimate and necessary forensic purpose at trial. Now, removing that component from witness statements creates a gap which would need to be filled, but the practice direction is silent as to how that is to be done. Now, we understand that the working group considered, but ultimately decided against a requirement for a pre-trial statement of facts, but there will need to be some means of telling the complete story. Now, in the business and property court cases to which the practice direction applies, that story will depend largely on contemporaneous documents, but the story will also provide vital context for the few facts that witness statements will now properly contain. And if, as Mr. Justice Andrew Baker recently said he envisages it, even in quite complex cases, a typical witness statement won't last for longer than 8 to 10 pages, and is going to be confined very specifically and very strictly to things the witness remembers and has first-hand knowledge of. There may be a slightly random quality to some of the things the witness says. And as Lauren has explained, there is no scope and it is not permitted for the witness to sketch in background that puts into context what he or she is specifically and properly giving evidence about. And there may also be a real risk that unless at some stage, and surely before the witness's evidence is actually heard, some context, some storytelling has taken place, that witness statement is not going to make a great deal of sense. So what are the possibilities? The first that comes to mind, I suppose, especially to the mind of counsel, is skeleton arguments. Now, if skeleton arguments are going to fill this forensic storytelling gap, then they are frequently going to need to exceed the limits on length, which various tribunals currently impose. But skeleton arguments are obviously not neutral documents. One of the things that Mr. Justice Andrew Baker, who's the chair of the working group, said is that he routinely edits counsel's skeleton arguments, which of course judges get in Word format, in order to take the spin off them, which counsel have inserted, as it were, so that he can have a neutral account of the documents of the case. Now, there's obviously a case to be made for a joint narrative document agreed between the parties. And if that were to be adopted, that would, of course, amongst other things, perhaps permit shorter skeleton arguments, because they would just be arguments rather than anything else. Now, one suggestion that has been knocked around is that factual narratives might be exchanged with witness statements. Others have said that perhaps that'll be too early, things would change, things would emerge, and that the appropriate time for some kind of document, whether it's a joint document or party documents to be exchanged, would be nearer to trial. But for the moment, the practice direction has left that question for case management decisions in individual cases. And whether that continues to be the case, we shall see in due course. What are the other possibilities? Well, one, and Dov touched on this when he was speaking earlier, are longer openings and or closings. And in another throwback to history rather than future, one remembers, of course, that in the old days, taking the judge to the key documents and explaining each side's cases about them, if they were disputed at any rate, was the routine way for the claimant's counsel to open a trial. Now, one of the consequences of this new regime will be that less time at trial will be needed for witness evidence, and correspondingly, more time would be available for openings and submissions. But in any event, I foresee that the pre-trial review will play a significant role in determining the shape of trials under the new practice directions, since it will provide the opportunity to tailor the procedure to the needs of a particular case, and perhaps even to the preferences of a particular judge, if you can be sure who you are going to get at trial. And that's a more typical experience, of course, in the commercial court than elsewhere in the BPC. In those cases where there is no PTR, and perhaps ideally in any event, the parties should obviously try to cooperate in finding a way to present the narrative, because it will be in everyone's interest to do so. Now, one of the other things that's been said about the preparation of witness statements under this new regime is that one approach will be to adopt a renewed focus on what has been described as the old advice on evidence approach. In other words, sitting down and thinking really of two consecutive questions. First of all, what do we need to prove in this case? And secondly, how is it to be proved in relation to each individual item or each individual issue? Now, the assumption in most BPC cases is that the answer to the latter question, how will it be proved, will usually be by documents. And in this respect, there may be a complementary role here for the much reviled disclosure pilot, with its greater focus on issues for disclosure. So it may be that this will be an occasion for more thought to be given by a party to what it needs to disclose for its own purposes, rather than to avoid criticism from the other side about what has not been disclosed and which might be helpful to them. Now, I've been talking so far about what witness statements must not contain and what the implications of that will be for the trial process. But I just wanted to move on to touch on a few of the things which Lauren has told us witness statements must now contain. Now, one of the first things that strikes me about that is the requirement that in relation to important issues of fact, a witness should, if practicable, apparently, say, first of all, how well he or she recalls the matter in question, and then indicate whether that recollection has been refreshed by considering documents. Now, that doesn't go quite as far as the working group initially proposed, because the first draft, or the initial draft of the practice direction, proposed a requirement for witnesses to say how well they recalled the matter before their recollection was refreshed by documents. But that was dropped in the final version of the appendix. But my general thoughts about this are that witnesses never get much credit for being tentative in their evidence. And this is despite the fact that there's now a significant body of research which indicates that it is the witnesses who admit to doubt or are less affirmative in their evidence who are frequently more likely to be recalling the matter accurately. But that, of course, is not traditionally how such evidence is received or assessed. What happens in practice, and we've all seen this, are that submissions are made that the evidence of a witness X is to be preferred to that of witness Y because witness X was more confident or more clear or sure. And ultimately, the evidence preferred by the judge, too often, one suspects, becomes that of the best performing rather than the most accurate witness. Now, under the new practice direction, even before it is evidence of a witness is tested in cross-examination, a witness is supposed to tell the court how good his or her memory is. Now, I venture to suggest that it may not be entirely realistic to expect witnesses to admit that their recollection is less than excellent. Now, Lauren has also mentioned the requirement, and this is paragraph 3.2 of the practice direction, that the witness, and I'm going to quote, must identify by list what documents, if any, the witness has referred to or been referred to for the purpose of providing the evidence set out in their trial witness statement. Now, one question that arises from that is whether adverse inferences are to be drawn from a witness who lists a large number of documents, or perhaps materially more documents than another witness. And this is something that the working group specifically considered. Now, part of their thinking is clearly to minimize the documents which a witness should be shown, and this is very important, I think, to be transparent about what the witness needed to be shown. But the reality, of course, is this, isn't it? That witness statements are likely to be prepared years after the relevant events. And it will, I suspect, be a relatively rare case where at least some documents will not need to be shown to the witness for the purposes of refreshment, or at least context. And with the best will in the world, there's an inevitable element of suggestion in doing so. It also seems to me that there's also the case of the witness who is the client or is a key client contact, and who in the course of giving instructions or assisting with disclosure at earlier stages of the case may see many more documents than would otherwise have been the case. Now, what's to be done about a witness like that? Now, that suggests, at least to me, that in some cases, some sensible and, one hopes, defensible distinction might need to be made between documents seen by the witness in that context and those which were more immediately considered in the process of producing that person's witness statement. Although in such a case, it might be wise for the statement generally to note that witness's involvement in other aspects of the preparation of the case in order both to admit, but also to kind of contain and explain that other inevitable exposure to case documents. And I mentioned the word transparency before. I mean, Andrew Baker has been very clear that that is fundamentally what this practice direction is about. It's being clear to everyone quite how things have been done, and therefore what weight can be given to what is said in the finished product. Now, the practice direction also intends to minimize the documents to which the body of the witness statement refers. And that, to me anyways, obviously gives rise to the possibility that the witness may be subject to cross-examination about documents and the list of documents which the witness says he or she has seen, even though the witness statement may not itself say anything about them. And that strikes me again as another issue to watch. Now, the practice direction doesn't merely state what a witness statement should look like, but in its statement of best practice, it goes into some detail about how the witness statement is to be prepared. Now, in one sense, this is only logical, because the concern of this reform, or reminder and re-emphasis of existing rules, as the working group would have it, is not just with the finished written product, but with the integrity of the whole process which led to it. And there is obvious scope for this to be open to question and challenge, not least in cross-examination. Now, having said that, I would expect that, as is the position now, the court would be impatient with questions about the mechanics of statement preparation, unless they were clearly justified by the actual format or content of the evidence which is given by that witness. Now, moving on, Lauren has already mentioned sanctions and summarized what they include, but has emphasized that, of course, the court has its full range of case management powers on this issue as on all others. Now, Andrew Baker, Mr. Justice Andrew Baker, has emphasized that he sees the new practice direction chiefly as assisting the profession rather than disciplining it. He is, as I think I heard him put it, more a carrot than stick man, but it obviously remains to be seen how other judges will conceive of it. Now, one thing I don't think we've touched on is it is possible for a party to apply for permission not to comply with the practice direction in whole or in part. And again, I've heard Mr. Justice Andrew Baker talk about this, and he says, well, that the mere fact that's there obviously suggests that there will be cases in which some departure from what the practice direction requires will be appropriate. And although he thinks it will be rare, it won't necessarily have to be a wholly exceptional case where at least some partial dispensation might be given. But once again, he emphasizes, and I would in turn emphasize, that it is really a question about transparency, making the application and explaining its basis in good time. Now, one thing is clear, and that's that although the new practice direction may in substance merely be emphasizing what witness statements should always have looked like, the divergence between the existing rules and long-standing practice is enormous. And the change of approach which will be needed in trial witness statements, which are signed from the 6th of April, will be difficult. And for a time at least, one might hope for some lenience towards the inevitable deficiencies in compliance. And of course, one can see an immediate distinction between oversights and misunderstandings as compared to deliberate failures to comply or to disguise how a witness statement has actually been produced. Now, one of the reasons why the working group adopted this statement of best practice, this rather oddly named creature at any rate, was that they thought that what the statement of best practice said seemed too vague for inclusion, even in the main text of a practice direction. However, the sanctions, as I understand them, potentially apply to failure to comply with any part of the practice direction, including its best practice appendix. And that obviously rather erodes the supposed distinction between practice direction and appendix. But much, and as Lauren has already explained, much in the appendix is not vague. It even tells us that in the interview with a witness, which you should ordinarily conduct in order to prepare the witness statement, you should ask open, not leading questions. And it also says that particular caution should be exercised before or when showing a witness any document they did not create or see while the facts evidenced by or referred to in the document were fresh in their mind. There is therefore much to get right or wrong. Now, finally, I thought that I might say something about examination in chief. Lauren has adverted to this. Some time ago, rumours reached at least the bar that the working group was considering providing for at least an element of routine oral examination in chief. Now, that possibility only finds its way into the practice direction as a possible sanction, but the idea was met with some consternation at the bar. Now, the ostensible reason for that was that it would lengthen trials, but I'm sure that there was also a less openly articulated concern that nobody at the civil bar knows how to lead evidence in chief anymore. Indeed, a whole generation of the bar has never needed to do it in practice, except for occasional and usually rash attempts at re-examination, or having to examine a witness who you have summoned to give evidence, and whose evidence you therefore have to lead in chief. But I wonder whether it might yet have its place in some cases. The judge can, and occasionally does, ask for crucial evidence to be led in chief, in relation, say, to a particularly crucial conversation. And if witness statements will now routinely be no more than 8 to 10 pages, as Mr. Justice Andrew Baker suggests, then examination in chief on particular points may not take up disproportionate time. Now, these would still be cases where there was already a witness statement, and therefore a risk that any examination in chief about something in that witness statement would have an element of remembering what the witness had said in the witness statement. But that is less of an objection if the witness is confined to what the witness really remembered. And of course, that's the whole purpose of this practice direction. Now, I could dilate endlessly on ever more fantastic ideas about what might happen in practice, but I think there's a limit to how much that is useful. But I hope we have, in our different ways and in our different paths, told you things you need to know and perhaps suggested some things that it might be useful to think about. Now, we've got some time. We have deliberately left some time for questions. Now, because I've been talking, I have not been keeping up to date with quite what they are, but except that when perhaps I might begin to the extent that I can help with a couple of questions, or at least one question that was asked about insolvency proceedings, because as Lauren has explained, I mean, there was a very specific and almost complete carve out for insolvency proceedings. And one of the questions that's been asked is what the rationale for that was. And as I understand it, it's really kind of twofold. I mean, first of all, what has been excluded by and large from the scope of the practice direction are those aspects of BPC practice which are not thought, at least currently, to exhibit the problems that the new practice direction is designed to remedy. And that is one of the things that's said about the or thought about the insolvency proceedings. I think this is perhaps a speculation on my part, that there was also some recognition being given to the way that quite a lot of insolvency applications will at least begin, and maybe in some cases not get a lot beyond, an office holder making a witness statement which gives a survey of facts which cannot possibly be in the office holder's personal knowledge, because the office holder is late to the party, as it were, but needs to be able to explain what appears to have happened on the basis of the documents that he or she has obtained access to. Now, I know that practice has not been uncontroversial in the past couple of years for other reasons, but I dare say that was also something of which the working group was mindful in deciding to which proceedings the practice direction should apply. But what one should bear in mind is that wherever there is a carve out, and so in other words, wherever there is a proceeding or to which the new practice direction does not compulsorily apply, it is open to a judge in the exercise of his or her case management of that particular application to order that it would apply. And one can quite see, as somebody else has asked, that if an application that starts off with an office holder's witness statement giving evidence which is not in his or her first-hand knowledge ends up being litigated on the basis of witness statements from people who really do know or should know precisely what happened in their first-hand knowledge, then there is no reason why not, and every reason why, you might think, this practice direction should be directed to apply to such evidence. That's all I was going to say about that aspect of the questions that I can see. There are quite a lot of them. It may be that Dov and Lauren have spotted some others that we might be able to help with.
Yeah, well, several of the questions did relate to what you've just outlined, Shantanu. The question of whether the judges are going to order that these provisions do apply to proceedings which are specifically exempted, and of course there is the possibility for the judges to do that, so it's worth having them well in mind, regardless of whether you think that to the letter of the practice direction that it's going to apply. There's a specific question about drafting witness statements for somebody who doesn't speak English, which I can probably answer quite quickly. It's in para 3.3 of the practice direction itself, so have a look there. But essentially what it says is it reminds you that a witness statement has to comply with paragraphs 18.1 and 18.2 of practice direction 32. For that purpose, it says a witness's own language includes any language in which they are sufficiently fluent to give oral evidence, not limited to their first language or their native language. And then it also goes a bit further and explains that it should be drafted in the witness's own language and in the first person, and refers to paragraph 23 of practice direction 32, which provides that a party who relies on a witness statement in a foreign language must also file a translation. So I hope that helps with that question.
There's a short question on witness statements being prepared for summary judgment and strikeouts. Those are not trial witness statements, so the rules that we've been talking about under the new practice direction don't apply to those statements. The rules in CPR, the pre-existing rules in CPR 32 do apply, but there's probably good reason to continue more or less as we have done in the past with strikeout and summary judgment statements. But have an eye on the existing rules. And keep the argument element limited, because otherwise you might get penalised in costs.
There are a couple of questions about the list of documents and disclosure and the sort of area around that. it doesn't say about the list of documents explicitly whether it should be included in the body of the witness statement. I suspect it's a matter where one ought to use one's judgment if it's a very lengthy list of documents, which, as we know, it shouldn't be. But if it's a kind of case where it's been necessary for it to be lengthy, it may be that you'll want to put an appendix and simply list it out in that way. If it's a short list, then very likely it's going to be suitable for inclusion in the body of the witness statement itself. And I have to say that's more how the wording of the relevant paragraphs reads to me. I don't know if anybody else had any thoughts to the contrary, but I think that's probably what's intended, just because it's not intended by way of the direction to be a very long list. Excuse me.
I think that's probably right. There's one question which may have occurred to quite a lot of people is, would it be advisable to get witness statements completed before the new rules come into force? Well, perhaps. I suppose the thing to bear in mind is that the sorts of witness statement that the practice direction is trying to prohibit shouldn't be being filed now. I think the only thing one avoids is the possibility of sanctions for not preparing them in the way mandated by the practice direction. But the reality is, and as the working group tells us, this is the way that witness statements should always have been produced. But it's because it has not been happening that the new practice direction has been thought to be necessary.
There's a question just very quickly about when the new rules come into force. It's from the 6th of April. So that one can be dealt with quite quickly. There's also a question about remedies for non-compliance. And somebody has said that they find that in a lot of their cases involving litigants in person, there are effectively no rules. The litigant denies all knowledge of the rules, whether there are remedies if they don't comply and the litigant behaves like that. As I outlined, there are a number of express provisions which apply to litigants in person only and make very clear that the rules do apply to litigants in person. I then come back to the sanctions part, which of course the sanctions equally apply to litigants in person. If the rules apply to them, so do the sanctions. So a different question perhaps as to whether judges will truly use the same or view in the same way non-compliance by a litigant in person and non-compliance by somebody who's legally represented. But in theory, at least, the rules will apply and should be sanctioned in the same way to litigants in person as to anybody else.
I think the reality is that judges will be capable of simply ignoring big chunks of witness statements prepared by litigants in person or by solicitors which are non-compliant. And they will say this whole, paragraphs 1 to 99 are irrelevant. They're all a bunch of commentary. I'm not going to deal with that. Solicitors will learn their lesson. Litigants in person probably can't be penalised much costs, but they won't get anything. They won't get any benefit for having spewed out pages and pages of matters which the judge thinks are irrelevant.
As far as sanction for us, or for our clients, parties who are legally represented, somebody has asked what should you do when you're faced with a non-compliant witness statement from the other side. Now, paragraph 5 of the practice direction, which is the sanctions section, does explicitly state the court may, upon application by any other party or of its own motion. So that seems to indicate that if you think you're faced with a non-compliant statement, there's nothing wrong. Indeed, the practice direction expects that you might apply yourself for any of the sanctions that are listed out or anything else you think is appropriate if you're faced with a non-compliant statement from the other side.
And the PTR is probably the best moment in many cases to deal with that, I would have thought, as the opportunity is there.
There are a couple of questions, I don't know, Dov or Shantanu, whether you want to answer these, about how you deal with clients who've been involved in the disclosure process and have therefore been reminded or reminded themselves of documents by way of that process, whether you ought to, whether that ought to be explicitly identified.
I think the answer, and I think it's a general rule of thumb, is the courts are encouraging transparency. So where a party or a witness has been involved in going through documents, they should say so. There's nothing to hide about it. There's more likely to be problems if they aren't full and frank about what they've seen. It's not a particular problem that they've seen documents necessarily. It's to be expected. but they should be transparent about it.
Yes, and I think I was trying to get at that in what I was saying, because there's as Dov says, there's nothing surprising about that having happened. But I think one needs to create a separation between those that have passed through the witness's hands and those which can properly be listed as having contributed to the production of the witness statement. But of course, that's a distinction which is easier to state than to apply. And it's also relevant to a very good question that's been asked about how to deal with putting an unhelpful document to a witness for clarification, confirmation as to what it meant. And the question is asked, presumably you would still have to list it even if you don't address the matters arising in the statement. And I think the answer to that is yes, but it does open up this whole wider question about however cautious you are being in accordance with the statement of best practice about what you show the witness. In other words, taking care so far as you can not show the witness something that he or she didn't see at the time. Sometimes you won't know unless you ask the witness and you show it to them. And where do you draw the line about when it then becomes something you have to list, even though it ended up being put to the witness and being eliminated? And again, I think that's going to be a matter of judgment. But it seems to me, but don't quote me, that it cannot possibly be the case that every single document that might have passed through the witness's hands, even in the process of the kind of one-to-one interview that it's envisaged might take place, can be appropriately listed as playing some material role in the production of the witness statement. But as I say, I think quite where you draw the line, and there will be documents which are in a grey area and which might cause problems. But that does seem to me to be something that's going to have to be worked out in due course.
There's a question as well relating to privilege. Now, para 3.2 of the practice direction, the last sentence states that the requirement to identify documents the witness has been referred to doesn't affect any privilege that may exist in relation to any of those documents. So the question says, and quite rightly, that there's a risk without that clarification that could be a hook for the other party to query any claim to privilege. I mean, I suppose it expressly identifies documents that you haven't disclosed through privilege, although you probably ought to have done that at the disclosure stage, or possibly ought to have done that at the disclosure stage, depending on which model you're using. But it does explicitly identify that that you don't have to, the fact that you identify a document in your list doesn't affect the privilege which may attach to it.
Yes, and although I can see the dangers, I've seen the question too. I wonder whether in practice there's going to be much difference between that and a disclosure list which identifies something as a privileged document. By definition, if you're not going to waive privilege, you may say that in your list that it has been looked at, or but you're not going to be saying anything about it in detail in the witness statement, because of course you really are into the territory of waiving privilege. So I wonder if it really does create any greater danger than already existed.
Perhaps finally, there are some general questions about the relatively narrow scope in terms of the court. So the fact that this only applies currently to business and property courts and only to the matters, to the types of proceedings we've identified. There are questions about whether everyone will just go to the QB, and also more generally about how long it will be before we see this regime extend to all courts beyond the business and property courts. Shantanu, I don't know whether you've got a view on that.
Well, I suppose it all depends how it works. But two things, I think. Somebody's asked about the rationale for excluding Part 57, and it's pointed out that, of course, quite a lot of probate actions exhibit just the problems that the practice direction is designed to remedy, but yet the practice direction doesn't apply to them. But of course, I would just emphasize what I said earlier, is that, I think this is work in progress about the precise scope of the practice direction, but it is always open to a judge in the business and property courts to direct that the practice direction will apply, even though it otherwise wouldn't do so. And so far as how long it'll be before it applies more generally, who knows? But I suspect that it will end up applying in civil cases more generally. Maybe there might be a financial threshold in order not to make very small cases too onerous. But it's difficult to see, excuse me, why it wouldn't if you accept the principle that witness statements are only meant to include and to describe evidence which is in the first-hand knowledge of the witness in question. And that applies to all courts, and for example, the Queen's Bench Division generally. So I really do see this as being likely to be extended further than the BPC in due course, but who knows when and quite how.
I echo that. Certainly when Andrew Baker was talking about this, it seemed a little bit of an accident, the way this practice direction has come in through the working group, initially of the commercial courts, and then it was expanded to the BPC more widely. And it seemed that that was a quicker route to get change and required less bureaucracy than getting a change, for example, to the rules themselves. And that's really just an accident. But I think as with so many other measures, we'll see this as some sort of pilot that will be rolled out. And I can imagine certainly active case management in cases where the particular court, whether it's the county court or when it's one of the insolvency proceedings or anything else that's been excluded, the courts will say, well, we're going to direct the witness statements be exchanged. Such witness statements must comply with paragraphs X, Y, and Z of this particular practice direction. They might not need to require wholesale compliance with everything, but the key provisions, I suspect, will be incorporated in a lot of orders now.
I would just thank all of you, so many of you, for joining us this morning. The working group, I heard Mr. Justice Andrew Baker claim only a couple of weeks ago that nobody should be taken by surprise by this practice direction because it's been discussed and has been trailed for a significant length of time. But we certainly had a sense that people might benefit from a crash course in what it's likely to mean, and likely to mean, as we've already explained, really quite soon. Of course, feel free, if people have questions that we haven't answered or which occur to you after we go offline, to email us, and we'll do our best to help if we can. And I think we're all going to wait with interest, but I think also a degree of trepidation to see how all of this works out. Anyway, thank you and good morning.
Thank you.